Thank you, Your Excellency. Chairman, thank you. Vice Chair, Special Rapporteurs, distinguished committee members. Police custody in Cameroon is regulated by the Code of Criminal Procedure by Articles 118 to 226 of the Code of Criminal Procedure. It is a measure of deprivation of liberty, and this measure is strictly regulated. That is to say that it cannot be implemented unless it is foreseen by law, and it can only be implemented through open legal proceedings. So the Code of Criminal Procedure makes detention an exception. Freedom and liberty is the rule, detention is the exception to the rule. The Code for Criminal Procedure indicates a special measure for certain circumstances, and the rapporteur indicated the duration which a judicial police officer must abide by when there is a preliminary inquiry or if there is an offence committed in flagrante. In such cases, the judicial police officers have the right to hold a suspect for this duration once. Under exceptional circumstances, the State Council may extend this duration when in custody. A suspect has, of course, fundamental rights that must be upheld and which are enshrined in the Code of Criminal Procedure. So during his time in custody, his or her time in custody, the detainee benefits from substantive and procedural guarantees foreseen by the Code, which is to be informed of the procedures, which is Article 119, the right to be treated with dignity, rest times during hearings, the prohibition of torture, and prohibition of all physical or moral coercion, the right to remain silent, Article 116 of the Code of Criminal Procedure, the right to a lawyer. This right is one upon which the Ministry for Justice places a particular emphasis, especially when visits to places of detention are organised. We ensure and verify that places of custody, so police stations or gendarmerie units, display the name of lawyers somewhere so that the person who is remanded can see those names and access a lawyer. There's also the right to nutrition and the right to be seen by a doctor. This is Article 123 of the Code of Criminal Procedure. There is also the right to be informed of the reasons for the custody, and all these rights are read out to the person being remanded and set out in the minutes, which is then sent to the State Council The person remanded in custody also has the right to be treated with humanity and to receive visits. So a judicial police officer receives training about this and usually complies with these provisions. There are trainings that are organised at the level of the defence and security forces in order to raise awareness about these practices. And this information, as the committee indicated, can take place at the initial stage of training, or it can be in-service training. Regarding the rules of custody, under Article 4 of the Code of Criminal Procedure, if there is a breach of the rules of custody, then there is nullity of the measures and arrest. So if violations of Articles 118 and others of the Code of Criminal Procedure are breached, then the reports and minutes are declared null. Victims of unlawful or abusive police custody have a recourse, which is that of filing a habeas corpus petition, which falls under the jurisdiction of the High Court. And then the relevant judge takes a decision on that petition. The law stipulates that if a habeas corpus is granted, then the release must be immediate. There must be the immediate release, or there must be an immediate appeal against it. A detainee also has a option to seek remedy through the Supreme Court, and this is set out in Article 226 of the Code of Criminal Procedure. So, police custody in Cameroon, as you can see, is very strictly regulated. It is regulated by the Code, and the Code uses the principles of a fair trial. There was a question that was asked regarding the Compensation or Reparations Commission. This commission, which is set up under the Supreme Court, is up and running today. It is composed of judges and legal officers who have a lot of experience in handling human rights violations and proceedings relating thereto. This commission has the means to take reparation measures against perpetrators of violations of, amongst other things, arbitrary, unlawful, or illegal detentions. And this commission is operational. In 2023, the Commission heard 19 applications and passed a judgment on 13 of them. In some of its decisions, the Commission granted the request for reparation on the basis of unlawful detention. This was the case in ruling number 23. Of the 25th of September 2024. It was the Saleh Abai versus the State of Cameroon case. In this case, where there was a multiplicity of restrictive measures, that is, measures that restricted the person's liberty that were taken, the magistrate for the reparations decided that there had indeed been violations of the person's right to freedom and therefore amounted to an unlawful detention. The state was therefore condemned to pay 40 million Cameroon francs to the victim. In decision 2022 of the same day, Mohamedi Dalla versus State of Cameroon, the state was also condemned to pay 50 million CFA francs, also for unlawful detention. Chairman, distinguished committee members, this is what I have to say about police custody and the Reparations Commission. Perhaps you will have additional questions seeking further precisions at a later stage, but that is what I can say for now. Thank you.
Thank you very much. Thank you very much for those replies regarding the custody issues. A number of aspects have been covered which were raised by the rapporteur, including legal assistance, medical care visits, and compensation where detention is unlawful. The concern I see of the members is to reflect compliance of our practices with the convention in the context of judicial practices in Cameroon. I would like to give the floor to the Subdirector of the Justice Ministry, who will cover a number of aspects. And briefly, first of all, I would like to talk about ratification of the optional protocol ratified by Cameroon in 2010. Now, there's an issue with the instrument of ratification, and we have been called upon several times about that. It is an administrative issue. It is going to be deposited. It was lost at one point, and it was lost in the administration, I mean. And when an instrument is lost, then you have to start everything again. So it's an administrative matter. And there's another consideration connected with that as well, but the ratification is public. The Parliament and the head of states ratified. Now, there were some administrative issues which meant that the procedure was not finalized. It's still underway. I believe in the next few weeks that will, however, be completed. And with that, I give the floor to the director to cover a number of issues on the death penalty, protection of victims, human rights defenders, and perhaps other issues on which she can add information regarding custody. Thank you.
Chair, thank you, Vice Chairperson. Thank you, the Special Rapporteur and other members of the committee. I would like to start by adding something to what the member of the delegation just said about the compensation at the level of the Supreme Court in charge of, about the commission at the Supreme Court in charge of compensating victims of illegal detention. I'd like to say that from the beginning, we did not have so many people seizing that commission, but with more and more awareness which is being raised by the government, more people are coming to the commission, and the commission is rendering decisions as the one he has just cited. The question that relates to the rights of LGBTQ, I would say the concept of LGBTQ does not conform to the moral values of the Cameroonian society, for which the state is the guarantor. The person who asked the rapporteur, the member of the committee who asked this question rightly said in our report, it is stated that LGBTQ is against the moral values of Cameroon. So Cameroon's position is not contrary to the provisions of Article 2 of the Universal Declaration of Human Rights and Article 26 of the International Covenant on Civil and Political Rights, which list prohibited grounds for discrimination. Furthermore, this position complies with Article 29 sub 2 of the Universal Declaration of Human Rights and Article 29 sub 7 of the African Charter on Human and People's Rights, which prescribed the respect for the moral and cultural values of each society. Moreover, homosexuality in particular generally only gives rise to investigations and possible prosecutions and convictions when it is practiced in the public arena or in the events of denunciation. Cases of investigation, prosecution, and conviction are few and far between. In any event, those concerned benefit from all the procedural and institutional guarantees of a fair trial. So it is not because somebody is LGBTQ that fair trial guarantees will not be ensured for that person. So people who come before the courts are treated equally. So as I was saying, all persons in Cameroon enjoy without distinction equal protection against attacks on their physical and moral integrity. So if an LGBT person is attacked, that person has the right to seize the courts for redress. And I saw in the shadow reports of one of the civil society organizations, a case mentioned where an LGBT person was attacked and the case was brought to court and the court heard the matter and granted compensation. The next issue I would like to handle is concerning human rights defenders. In Cameroon, the normative framework on public liberties, that is freedom of association, freedom of assembly, freedom of expression, and others, and the relevant treaties ratified by Cameroon enables human rights defenders, individually or collectively, as part of civil society organizations, to carry out their activities freely, so long as they respect the laws in place. So like everyone else in Cameroon, human rights defenders enjoy the protection of administrative and security authorities. In addition, allegations of violations of their rights are investigated and, where appropriate, prosecuted, and perpetrators punished and victims granted compensation. So the case that was mentioned is not an exception. So it does not matter whether you are a journalist, whether you are a human rights defender, whether you are somebody else in society. When your case comes before the court, the case is treated according to the law. Fair trial principles are respected. It is also important to mention that Cameroon also cooperates with regional and international mechanisms that have a mandate to defend human rights defenders. This is the case with the Special Rapporteur on Human Rights Defenders and Focal Point on Retaliation in Africa. Furthermore, through various public administrations and entities, the state of Cameroon supports human rights defenders, on the one hand, by establishing collaboration platforms, and on the other hand, by receiving and processing their petitions alleging human rights violations. So Cameroon takes measures to respect the rights of human rights defenders in various ways. And I would like to say here, when we talk of different platforms, we include even the preparation of this report. Civil society organizations came in to give their own point of view under the leadership of the Cameroon Human Rights Commission represented here. So there are a lot of instances where human rights defenders and government stakeholders work together. Coming to the question on the death penalty, the member of the committee rightly said Cameroon is a retention state and went further to ask whether this moratorium concerns only execution of sentences or it also concerns the passing of judgments, that's the sentencing of persons to a death penalty. The courts in Cameroon continue to sentence accused persons to death. And it is important to mention that this is done only for the most serious offenses. And when an accused person is sentenced, is convicted and sentenced, he or she has the right to apply to the President of the Republic of Cameroon for pardon. And this is usually done through the Ministry of Justice, specifically through the Department of Criminal Matters and Pardon. And I want to assure you here that in all of those cases, pardon has been granted. That is why for more than 35 years in Cameroon, we've not had anybody executed. So some people may ask, but why has Cameroon left the death penalty in its penal code? It is simply for reasons of dissuasion, to dissuade other people from committing heinous crimes. We were also asked for statistics on the number of persons who have been sentenced to death during the reporting period. For the set statistics, we will be able to provide them later to the committee. Another question was asked concerning the Cameroon Human Rights Commission. There was a question on whether it has enough human resources, whether it is independent, whether it has an independent budget, whether it is free to visit places of detention, not only prisons or police cells, but other establishments like psychiatric homes. Coming to the issue of resources, I would like to say that before the adoption of the law creating and organizing the Cameroon Human Rights Commission in 2019, the commission used to sit a few times a year. But since 2019, the commission sits on a daily basis. So they are permanent staff, they are members of the commission. And for the issue of budget, we have seen the budget of the Cameroon Human Rights Commission increase year after year. And on the issue of whether the subcommittee on the prevention of torture has a separate budget, the budget of the commission is voted as a whole. On the question of the commission members having the right to freely visit places of detention, not only police cells or prison cells, the commission has done that regularly. And the commission's visit is not limited to police stations or gendarmerie brigades or company cells. It has gone beyond that. The commission visits psychiatric homes and other places of detention. I may want to take the example of the visits that the commission carried out last year. Last year, 2023, the commission carried out a total of 614 visits to places of detention, which included hospitals. That is, we have a hospital in Yaoundé, which has the required specialization to treat psychiatric cases. The commission was there. The commission visited 59 places of detention in the Adamawa region, 55 places of detention in the Center region, 3 places of detention in the East region, 106 places of detention in the Far North region, 54 places of detention in the Littoral region, 85 places of detention in the North region, 162 places of detention in the Northwest region, 28 places of detention in the West region, 9 places of detention in the South region, and 45 places of detention in the Southwest region. So these are the number of visits that the Cameroon Human Rights Commission carried out last year with the specific numbers as per region. And the Cameroon Human Rights Commission publishes its independent report every year on the situation of human rights in Cameroon. So for now, that's what I can say about that question relating to the Cameroon Human Rights Commission.
Okay, thank you, Madam Director, for this relevant input. I think, honorable members, you have listened the effort doing and made by our government to modernize our system and to be in conformity with the international convention with the respect of human rights. Now, let me add on what they said, generally some element with regard of refugee, migrant, and internal displacés.
I will give some overall information. There was a question about freedom of movement for refugees, migrants, and IDPs. Now, Cameroon has over 500,000 refugees, mostly from the CAR, some from Nigeria, Rwanda, but also from a number of other nationalities. The policy, the hosting policy for refugees in our country is based on the Global Compact on Refugees and UNHCR's program. 2 years ago, rather, the High Commission made a visit. I was part of that. We went to a number of refugee camps, particularly in the far north, Minawao, one of the largest camps for refugees. The identification issue was raised. We have an assimilation policy, meaning that we don't distinguish particularly between nationals and refugees, particularly since most of them are from neighboring countries like Nigeria, and they have all rights, all basic rights, the right to shelter, health, education, to freedom of expression, to education. The Office of the High Commissioner for Refugees with partners is helping our government to build schools, and refugees are admitted to basic education, secondary and higher education. So we have this policy which is in line with the international conventions and with human rights generally. Migrants' rights are protected. On transit, we attach great importance to their rights. On identification, there is an issue of budgeting. Working with UNHCR, our government is creating a special program. We have to count the number of refugees and monitor it. That is being done by both our government and UNHCR. There was a question on mass graves. Now, as ambassador of Cameroon, that's the first time I've heard mention of these. We have been monitoring to avoid this type of abuse. We do not have this type of mass killing. And that information would need to be verified. Information comes from civilians sometimes who report mass graves, but our government is not carrying out mass killings. So when cases are reported, the state institutions investigate. Nationally and internationally, we are working to ensure that human rights are protected. I was horrified to hear that there could be mass graves in Cameroon, but if there is reliable information, then we could seek to investigate. Maybe some exist and the government doesn't know about them. So I wanted briefly to allude to that. Coming back to refugees now, we were asked about IDPs. These are Cameroonese citizens. In our social tissue, we have a hosting policy. In my family, there are a lot of people who've come from the northwest and the southwest, and we take them in. Families take them in. I'm not going to say that everything is perfect, but in that connection, the government is keeping an eye on matters to ensure that all Cameroonese people have their rights respected wherever they are, their basic rights as citizens. And we don't have any hierarchy among our citizens. They all have the same rights and responsibilities under the law. Distinguished members, this is some preliminary information that we're able to give on that, and we will certainly have more details to add.
On
English.
okay, on military court. Okay, you can go on, please.
This issue of civilians being tried before military tribunals has come up over and over again. But it is important to precise that in the Cameroon judicial system, the military tribunal is not an exceptional court, but a court under ordinary law with special jurisdiction. So it is clearly stated in Article 2, Sub 1 of the Code of Military Justice. What I have just said, it is clearly stated in Article 2, Sub 1 of the Code of Military Justice. And on reading the provisions of Article 8 of the Code of Military Justice, it is generally clear that this tribunal has jurisdiction over military offenses. There are many of them. I will not go to in the Cameroon judicial system, the military tribunal is not an exceptional court, but a court under ordinary law with special jurisdiction. So it is clearly stated in Article 2, Sub 1 of the Code of Military Justice. What I have just said, it is clearly stated in Article 2, Sub 1 of the Code of Military Justice. And on reading the provisions of Article 8 of the Code of Military Justice, it is generally clear that this tribunal has jurisdiction over military offenses. There are many of them. I will not go to list them. It's a long list. They are contained in Articles 30 to 67 of the Code of Military Justice. It is important for me to come back to training. The magistrates who preside over the military tribunals go through the same schools like the civil magistrates. They all have the same curriculum. They go through the National School of Administration and Magistracy and receive the same training. And when military magistrates sit, they don't sit alone. There are always civilian magistrates who sit with them. And even when matters go on appeal, you still have civilian magistrates. In fact, there is no military court of appeal in Cameroon. The court of appeal are there to hear cases emanating from lower civilian courts, as well as the military tribunal. So all appeals go to the Court of Appeal. And again, there you have civil magistrates who sit with the military magistrates. So, moreover, persons prosecuted before military tribunals, whether be they civilian or military, benefit from the guarantees of a fair trial in the same way as those prosecuted before other criminal courts. It is clear from the provisions of Articles 13, 15, 19, and 25 of the Code of Military Justice that the rules governing the initiation and conduct of public prosecutions and the rendering of judgments are those of the ordinary law, which means that the criminal procedure code which applies in civilian courts is the same criminal procedure code that is used in the military courts. In addition, as I already said, decisions handed down by the military tribunal may be appealed before the Court of Appeal in the same way as decisions handed down by all other courts of first instance. And to conclude, no binding international instrument prevents the trial of civilians by military tribunals, provided that the law is respected and the parties are guaranteed a fair trial. Thank you.
Thank you, Madam Director. Please let me add a few elements with regard of refugee. I've just received. C'est des éléments nouvelles.
This is new information and it's important. This is something I want to tell you about. So the refugees in Cameroon. There's a joint team of national security working with the foreign ministry, providing biometric cards to refugees. So those biometric cards do exist. They're issued to refugees. And on IDPs. A lot of them have come to our country because of climate change, or rather they have had to move around our country because of climate change and the various crises affecting our country. With that, I will give the floor briefly, if I may, if the chair agrees, if we still have time, 2 minutes, to Mr. Patrick Belambert.
Excellence.
Excellencies, just on custody, a clarification. The rapporteur raised the issue of registers, custody registers, and they do exist in the police and gendarmerie brigades. The public prosecutor can at any time verify those registers. The office of the public prosecutor has that mandate. On the national prevention mechanism, the team from that mechanism is made up of doctors. The question of access to doctors was raised, and reports of violations observed in detention facilities are sent to the NPM and to the prosecution service, and then there is follow-up. mechanism. The team from that mechanism is made up of doctors. The question of access to doctors was raised, and reports of violations observed in detention facilities are sent to the NPM and to the prosecution service, and then there is follow-up. Thank you. Microphone, please. Microphone for the speaker. Thank you. Thank you. Thank you for allowing us to give those clarifications. And with that, I hand the floor back to you, sir. Thank you. Thank you, Ambassador. I would like to thank you and your delegation for your preliminary replies. And tomorrow, of course, there will be more time to address all of the questions that were raised. One clarification that I should make. A number of members of the committee are requesting statistical data on issues, and on the tomorrow we have completed our dialogue, the delegation will have 48 hours to send to the committee any additional information that could be relevant to the discussions of the committee. With that, we come to the end of this first half day, and this session stands adjourned. Thank you.